So you good to go? Secretary, Merritt and counsel, Ms. Losico, you're standing, so I'll talk to you.
If you would like, we could go through the 3 motions for discovery that I think still have outstanding items.
What number are they?
We'll start chronologically with the 5th.
Okay. Okay.
We have made a request to DPS with respect to item number 3. I have been told that the IT department at DPS is doing their best to retrieve those items.
Do they need any help from me? Any order that may help?
We don't think so, Judge.
Is there a guesstimate of time?
I'll have them work a little bit faster. I don't have an idea.
Is it the 97 thing in line, or are they working on it and it takes this long to do whatever they're doing?
In my experience, trying to retrieve archived emails, it is a time-consuming process.
Okay. Mr. Lamb, do you have a time request? I know, yet other than yesterday.
I certainly don't want to put the cart before the horse, but I think by setting a trial date, we will be in position to better gauge discovery, because we'll have benchmarks from which to work.
Okay, well, with the current last day of June 26th, it would be a normal practice to set trial like May 26th, if that's a work day. Mr. Leiter?
I would just say that based on my trial schedule with 2 defendants, including custody substantially longer than Mr. Merritt, I don't anticipate, frankly, at least being available within the last day. I understand the defense's request. I think at this point, I think it's reasonable to set a trial date at least 2 weeks before the last day, with defense counsel and the court's knowledge that I have 2 separate homicides that I intend to participate will go to trial, and that will lead me at least until July, when I'd be available to try this case.
That'll take a written motion.
I understand.
So, but in order not to create something that's not doable, I would set trial in June 26th is actually a Sunday, so the last day is really June 27th. I set trial July 9th, June 9th. And then if there's any need to pass the June 27th date, I'll need that in writing.
Yes, sir.
So we have a June 9th trial setting on Mr. Lamb.
That is agreeable to the defense. In terms of length of trial, we anticipate 6 to 8 weeks. Jury selection will take some time, as the court can imagine. jury questionnaires would likely be advisable given the high-profile nature of the case.
That's why I picked a Thursday, so that you guys would have the weekend to read them. So, the DPS is working on what you're asking for in your fifth, and it's an arduous process. How much time are you affording them before we come back here?
Judge, would it be feasible to have that information 30 days from today? Is that reasonable in this court in the state's eyes?
So I'll make it, that's the default position. It's reasonable, and like the rule says, they need to tell us why it's not. So the court would order that discovery request 5, subpart 3, be provided to the defense within 30 days. Ms. Losico.
Next, staying with the fifth motion, is number 5. Your Honor, the state does not believe that the items requested in number 5 are relevant to the crimes charged. Additionally, Your Honor, they have not established an undue hardship in which a public records request to DPS could not achieve.
Again, that's a different area. Let me ask, are these things on, I don't even know if they're on the web. If you look at their website, whether they would be on the web, or if they're standard, you get them at any police academy, or whether DPS has a unique policy and procedure regarding report writing.
I have not looked at the DPS website to see if the items are on.
What's the harm to provide it?
Well, Your Honor, the state does not believe that this is relevant to any issue with respect to the crimes charged, and therefore it's not within the purview of discovery.
Based upon the arguments earlier, one of the defenses is that it was a core investigation. And I'm making no relevance findings today, but the standard today is whether it's relevant or may lead to relevant information. The court would grant 5 of subsection 5, discovery request 5, as it relates to report writing.
With the same March 9th 30-day deadline, Your Honor.
I would think that can get sooner, but I'll give you the 30 days.
If we could now go, Your Honor, to the 6th motion for discovery.
Yes, ma'am.
6 up Vanessa, I'm sorry.
With respect to item number 2, the reports related and the analysis have been disclosed and were disclosed on December 3rd, 2015. The notes and anything else related to that analysis, I have been told, has been placed in the mail today from the outside agency that completed the analysis. So as soon as we receive that, it will be disclosed.
Okay, so 2 out of subsection 6 may be moved as granted.
With respect, I'm sorry, Your Honor, I went out of order. With respect to number 1 of the 6th supplemental motion, we have provided all of the reports and notes related to both Mr. Polkowski and Ms. Pelosa's work on the case. We have also requested the emails and the other items. Again, that is an arduous task. Once we receive them, we will disclose them, if they even exist.
in the very first discovery request as opposed to the one that's entitled to first discovery request. That was your more generalized request, I thought.
Your Honor, it was more generalized, but in the sixth supplemental motion,
It's in number 6 then, more specifically?
Yes, I'm sorry, it's under number 1 of the 6th supplement.
Good. So, again,
it's the ancillary items to the case file.
all right. The court would grant subsection 1 out of the 6th motion, but believes that it is, the state is attempting to comply with that, with the same 30-day window.
Your Honor, and now we go to the 8th supplemental motion.
Okay?
And under number 3, those also have been requested, and they are working on being compiled as well.
Okay. The court will grant the request for subsection 3 out of the 8th motion discovery and take the state at its word that they're doing their best to get that as soon as possible, but no later than 30 days. 3.
I believe that is all that is outstanding.
All right. If there's any other disputes, you let me know. We ought to set something in 30 days.
I think it would be prudent to do so just after the 30-day discovery cutoff for the items ordered today.
Just for scheduling, yeah, Friday is probably best.
March 25th.
The 25th, Ms. Losico?
One moment, Your Honor.
Jason, something else can we do with the phone?
That's fine with this, with me. I don't know about
Divider?
Mr. Ryder.
A moment, Judge.
Sure.
You can.
Well, they're checking. They got little things. Mr. Farragut, will that work for you?
I think I have another case out of county that day. I don't have my calendar with me, but I think I do. So if we can change it, if not, Mr.
I can set it for another day.
Handle it.
Better to do it on a Friday or a weekday. Mr. Leiter's in trial. Is Friday better?
Fridays.
Well, in terms of complex case, essentially what's going to be a complex case management discussion of discovery, which state believes we will have largely complied with the request. I don't anticipate a lengthy hearing. I think we could do it during the week on 8:30 setting. It would be fine. For the state.
When are you back, or when are you gone? Just that one day? See. Well, we have an oral argument set for March 4th, but that was for something else. That's the.
What was it for?
I'm glad your looks are the same as my looks. I hate that. And how about the 24th, Mr. Farragut? Mr. Lamb?
Sure, fine.
Mr. Leiter?
Fine.
Losico? All right. Back on the record, the court will set a case management conference for March 24th. If anyone needs anything in advance, just submit it, including what we do know we need is the 15-1G order. If you just email it, I will sign it. And if the DPS folks need any orders to get what they need, just submit them and I'll sign them.
And Judge, I would like to request a clarification with respect to the court's order before we took a break.
Yes, ma'am?
And it is only specific because, as I count them, defense has made a request with respect to 8 separate alleged shootings. However, they have only provided a DPS DR number, or any DR number for that matter, for 3 of those 8. And so their request indicates multiple police agencies, and the state would ask that the court order that the order only be to DPS at this point, because we again, it would go to a fishing expedition if I have to call every police agency along the state with respect to.
Ask, again, limiting it to those 8, if there was a shooting incident reported to any police agency, would DPS be notified?
I think it depends on location, Your Honor.
Well, they do have specific locations in their requests. So if that's going to, again, I'm going on the fact that you have a theory of the case that's very tied to the ballistics, and ballistics has a general characteristics and a very specific characteristics. And what I deem relevant is those that are general characteristics that you are aware of. If you don't know and you've made a good faith effort to look, that's an answer.
Okay.
But know that I'm also asking you to seal any materials related to what's requested so that if down the line somebody wants to look at what we've done today, they can look at what we've done today.
Understood.
Any other questions, Mr. Seeker?
No, Your Honor. Thank you.
Anything else, Mr. Seeker?
No.
Mr. White?
No, Your Honor.
Mr. Lamb?
No, Your Honor. Thank you.
Mr. Farragut?
Your Honor.
Sure.
Media.
Right.
What I would probably have to do is have a look at the